Welcome to the Family Law Channel. The state of California Supreme Court ruled last week minors who ask for a parent while being questioned in connection with a crime are not afforded the same protections had they explicitly invoked Miranda. My guest is retired Superior Court Judge in Santa Clara, California, Eugene Hyman. Thanks for joining us, Judge.
Thank you.
So let's talk about this ruling.
Well, we have to first get a little bit of background information. This is what's referred to as the Fifth Amendment case. That is, has someone invoked their right to request counsel and therefore cut off the questioning process until, in fact, they have an attorney. This was a California Supreme Court case which was to decide for California whether or not Miranda had been violated. Under the federal standard, Miranda had not been violated. That is, under the federal case law, a child asking for a parent would not invoke the right to remain silent, was not the equivalent of asking for an attorney. So in this particular case before the state Supreme Court, the question was, did a child who requested a parent invoke the right to remain silent? Were they, in essence, asking for a lawyer? If this had been a Fourth Amendment case, that is search and seizure, then California, under a proposition passed over 20 years ago, this would not have been a discussion because under the proposition, the California standard for search and seizure review is federal decisions. Being a Fifth Amendment case, however, this was still open for interpretation under the California Constitution. That is, California could not be more conservative than the U.S. Supreme Court in the subject area, but could be more liberal. In this particular case, however, the California Supreme Court decided in agreement with the federal Supreme Court and decided that, in fact, requesting a parent was not the same thing as requesting a right to remain silent or the same thing as requesting an attorney. The California Supreme Court said that an average police officer would not know that requesting a parent was the child's effort to invoke the right to remain silent. The concern that I have in terms of reviewing this case is that we have a lot more research now than we did 10, 15, 20 years ago with respect to child development, with respect to teenagers. And we know that children's brains with respect to decision making is still being developed even into the early 20s. Given the age of this particular child, which was quite young, I would have expanded the decision and I would have said, yes, given the age of this particular child, this child was, in essence, by asking for a parent, was asking for assistance equivalent to asking for an attorney, and I would not have allowed questioning. But that is not how the court ruled in this case.
All right, Judge Hyman, thank you.
Thank you.
You're watching the Family Law Channel here on the Legal Broadcast Network.